Sharifa Tharpe. I'm here live to take your questions. So go ahead and put your questions in the comments. I usually come on around 12 to every day, Monday to Friday, to talk to you, to take your questions. I thought today I would give you the floor. I want you to ask me as many questions as you can. Of course, these should be immigration related questions. Anything that's immigration related, go ahead and put your questions in the comments and I will answer those questions. I'm leaving it to you to give me those questions. In the meantime, while I wait for your questions to come in, what I want to do is I want to go ahead and tell you how to get in touch with me. Because if you have very specific questions, so if you have questions regarding something you want to apply for right now, an action you would like to take, what you qualify for. You are right now, you're serious, you want to make sure that you do it right, no mistakes, that you have a smooth process with as little delays as possible and not unnecessary delays, then that's where you should schedule that appointment and talk to me. We will go through your particular situation and I can advise and represent you once we determine you qualify. You can go to the link in the profile, on the link in the profile page. So there's an About Us page on Facebook, there's a profile page, there's also a profile link on Instagram. Go ahead and join me there and ask your immigration and go ahead and schedule your appointment. Today, right now, I want you to ask your general immigration question and I will answer. So go ahead and put your questions in the comments and I will go ahead and answer. Okay, so we have one here. Hi there. I just want to ask why my son approved over 21, even I filed the application when he's still 20 years old and the priority date is he is still 20 years old. So this may be because there's a specific law in place. So I'm thinking here what you're saying is so he's over 21. At the time you filed for him, he was under 21. And if you are a US citizen, then it can freeze his age. So they would still move ahead and approve it because there's a special formula that they use to determine whether, for immigration purposes, they can freeze the age. So in this case, if you're a US citizen, then they would freeze his age for purposes of approving that petition on the date, on the priority date. If you're a permanent resident, they would then apply a special formula, and that formula would be based on when the immigrant visa became available and when the petition was approved. They would take that time period and minus it from his age to see if it still brings him back to the age of 21. I mean, under 21. So that may have happened in this case, but keep in mind that I am not your attorney. I don't know what your situation is. And if you're having any doubts at all, this is where you need to make sure that you get personalized legal advice to ensure your process is smooth and that you get through the way as expected in your process. I'm definitely available for that. So you can go ahead. And as you can see, by the way, you see on YouTube, on Facebook, you see my number scrolling in the ticker at the bottom of the screen. So you can call that number to schedule your appointment right now. There are scheduling coordinators who are available. Thanks for that question. All right, so I see another one here. And okay, so can you help my common law wife with an adjustment of status to include permit to work? We have a baby that was born abroad. She should be American citizen by birthright. Please respond. So definitely, now when you do, if you're a citizen and you have your child, yes, there are certain circumstances under which that child is born a citizen. It's just that now you have to register their birth abroad. I have done this for my clients. So yes, I know that this is a possibility. As to whether this can be the case in your situation, that's where you, if you would like assistance, you would like representation on it, you can call, schedule an appointment, and we can sift through those details. As for adjustment of status for your common law spouse, now with your common law spouse, it all comes down to is your common law marriage considered legal where you are, and would it be recognized as a marriage? So you're going to have to prove that for your spouse to successfully get permanent residence based on the marriage. We can also talk about that, but whether or not they're going to recognize common law marriage is going to depend on a number of factors. Where are you residing? What state are you in? Which country are you in? And do they recognize it as a marriage, a legal marriage? And in order, and common law marriage, is a type of union where you didn't formally get married in the traditional way, but because of maybe the length of time that you have been together and all the property you've accrued together and all the way that you've lived out your life together over a certain period of time, it can be recognized as a marriage in certain countries and even certain states. So we have to sift through all of that to determine how to move forward. Okay, how can the wife of a Cuban resident receive a green card? So it depends. Now, being Cuban alone is not going to make the spouse gain any kind of status. But if the Cuban resident qualifies for permanent residence, so there's what's called the Cuban Adjustment Act that allows the Cuban resident to apply for permanent residence upon entering the United States. And in that case, they may be able to apply for permanent residence on that basis, or after that Cuban immigrant turned permanent resident becomes a permanent resident themselves, they can then sponsor the spouse. Whichever process you're going to take is going to depend on a number of facts. It's going to depend on the qualifications of the Cuban immigrant and whether they can receive permanent residence, and where is the wife? Is the wife in the United States or outside of the United States? Because remember that there are a number of layers here. If the Cuban immigrant is going to become a permanent resident and then sponsor the spouse, then does the spouse themselves have some sort of visa or legal status in the United States to do adjustment of status? Or if they're outside of the United States, then it's going to have to be consular processing. And so you definitely need to schedule a consultation so we can see how the immigrant spouse, the Cuban immigrant spouse, can turn around and help the wife to qualify for residence. But it could be possible. It's just that we have to tear away those layers. How long it's for a green card to be approved? So, oh boy, that's a loaded question, and it's going to depend, right? Um, so if you're getting and I'm going to break it down really quick. If you are applying for adjustment of status, that means that you now qualify to get the visa, the immigrant visa. Now you're going towards permanent resident. If you're here, you're about to apply for adjustment of status, you could be looking at a year to a little over 5 months to a little over a year. However, if you are outside of the United States and you are applying now for the petition first, it could take anywhere from 18 to 24 months if a U.S. citizen or legal permanent resident spouse is sponsoring you, a citizen child who's age 21 and over, or a parent and you're under 21 and unmarried. If it's a U.S. citizen parent and you are an unmarried son or daughter who's 21 and up, it's taking 6 to 7 years. If you are the son or daughter under 21 and unmarried of a permanent resident, then it's taking about 18 to 24 months. If it's you are the son or daughter of a permanent resident and you're 21 or over, it's taking about 5 to 7 years. If you are the married son or daughter of a US citizen, and only US citizens can sponsor their married children, it's taking 12 years. And if your sibling is a US citizen, age 21 or over, and they are ready to sponsor you, it's taking 14 years, mostly in the Caribbean, 14 years. But in Mexico and some Asian countries, it's taking between 19 to 22 years. So it really depends on what category you fall in, what stage of the process you are at now. If I apply for VAWA, when can I file for divorce? So great question. Now, you can file for divorce at any time. You can even file for divorce before it's important though to make sure by then you have your attorney before you file anything. That's my rule of thumb. And if you've been watching me and following me, you'll know my rule of thumb is if you're going to take any action at all, that's a point where before you do anything, you need to talk to the attorney, because you don't want to talk to the attorney afterwards, then find out you did something wrong and oopsie daisy, it's hard to fix it then. So make sure before you take any action, which includes marriage, it's divorce. So marriage, divorce, if you're going to move anywhere, if you're going to stay in the country past the time you are permitted, if you're going to leave the country after overstaying or leave the country and you then plan to apply for adjustment of status, all of this should be, you should run this by an attorney because there are complex laws regarding these kinds of situations. Divorce can happen before you apply for VAWA, but after that divorce is finalized, you have up to 2 years to apply. So you just want to be aware of that deadline. This is my rule here, though, is remember VAWA is for situations where you're experiencing mistreatment, abuse, extreme cruelty. If you feel like this is affecting your mental state, your welfare, your physical safety, prioritize yourself. Put yourself first, get to a safe place. Don't think about, I'm going to keep putting myself in harm's way until I can get this VAWA filed. Because that can actually interfere with your VAWA petition. I mean, it is possible to apply while you're still living in the same household with the spouse, for example, or while you're still married to the spouse. But if this spouse, you have to be very careful. You have to tread lightly, make sure that correspondence only goes to, for example, with my clients, correspondence only goes to me to make sure my client is safe. Nothing goes to their address. And the USCIS is well aware of this too. So they usually never send correspondence to the home unless, of course, the client or the individual, I should say, doesn't goes ahead and they apply on their own. They apply without an attorney. But at the end of the day, you need to make sure that you're safe first, right? And VAWA can come afterwards. If you do file for divorce, make sure you are aware of that deadline that you have and you can't wait till right up to the 2 year mark. Make sure you apply in less than 2 years after that divorce. All right. You're welcome, Mindy. Okay. Shani, you agree. I'm glad. All right. So if my visa got canceled, will I be able to get another US visa? If it got canceled, it depends on why it got canceled. Chances are, if it got canceled because of an immigration violation, I'm going to be very straight up with you. You are facing an uphill battle to get that visa again. At least you'll be facing an uphill battle for a while. right? Because once you have once you have, or they have on record that you have a past immigration violation, that trust has been broken, and they likely will not look at you the same way. It's kind of like a relationship where once that trust is broken, there's just no going back. Or even if the couple reconciles, it really takes a lot of time to get there. Well, the same goes with the visa. If it's canceled because of a past immigration violation, and sometimes the consequences are more severe. Along with the cancellation, you may get misrepresentation, working without a permit, as well as other things. And if that's the case, it's going to be an uphill battle. You really have to come good to get that visa. Now, there are also waivers available, but there are special requirements for waivers. And it's going to depend the type of waiver you apply for. Waiver is a way to get forgiveness. And waivers, the requirements depend on, are you going back for a permanent resident? And keep in mind that certain violations of the visa don't necessarily disqualify you for the green card. It just disqualifies you for another visa. So this is where the consultation is going to be very important, to see if you're going for a green card, if it's going to affect the permanent residence, because it may not. It's just that you may not be able to travel until you get the visa to get your green card. All right, examples of those violations. So I did mention them. And so lying to the immigration officer, that's a big one that leads to a lifetime bar from getting any immigration benefit. You always have to get a waiver. So you never want to be lying to an immigration officer. And what I like to say here is omission is the same as a lie. So for example, if you apply for your visa and you know you have children, but you just don't put it on the application, that's the same as a lie. So don't try to construe it as any different, or to say, I just didn't put my kids down. That's still considered a lie, an omission. And you will, if they do find this out, you will be found charged with misrepresentation or fraud. Another is working without a permit. If you're working without a permit, then that can also, they will revoke your card, your visa. And if you're at the airport or at the border, they will then send you back through expedited removal. So those are some of the common ones. Now, when you're coming in, I just do want to give you another piece of information. When you are coming into the country, keep in mind that the officers they do have the resources to be able to check your phones, check your pictures, check your apps, to see if there's any information that's going to reveal that you have committed an immigration violation. And this is oftentimes how they will find, they can go into the app, your bank account app, or look at things that you've even tried to delete, to see if they can find records showing that money was deposited into your account on a regular basis, or even on a one-time basis at the same time that you were visiting the United States. So you want to be very careful to make sure that you're not working without a permit, or taking money that may be construed, taking money here that may be construed as working. Also, keep in mind that sometimes even coming in and saying like, oh, you're coming to help someone with their baby, they have construed that as working without a permit. I know it's something we do as Jamaicans. We help each other with the baby. When one of us have a baby, all the family come rally around. People take turns for weeks after the baby's born to help take care of the baby. I know that. But the immigration officers, sometimes I have seen this, where when someone is coming in and saying, Even the grandma is coming in and saying, I'm coming to help my child with their baby. They will use it as an excuse to say, well, that's work. That's considered work. You need to we're not going to let you in. So you also have to be careful how you communicate the reasons you're coming here to the United States. You want to make clear that is not having to do with anything labor or anything to do with work on a regular basis. So that's just a side tip regarding coming in on the visa, the visitor's visa. And it is a popular topic, right? Coming in on the visitor's visa. And since I'm on that topic, I am going to talk about the length of time that you are here for. If you do max out the time, right, that you are staying here, you need to make sure that you can explain the reason that you stay that long and how is it that you are able to support yourself for that long. Because usually when you max out the time, the length of time, the 6 months, if they give you 6 months that you've been here, the number one suspicion they have is that you were here working. And so you have to be careful to, if you are going to max out your time, or if you travel very often, if you're going to travel every few months, you want to be able to articulate that to the officers, the reason you're here, and to be able to show proof that you're not getting your financial support from any source in the United States as in an employer. All right. So let me see. Any more questions? Any more questions? Put those questions in the comments. That is why I'm here. I'm here to answer questions today. I don't have a particular topic. I just want to hear your questions so that other people can hear your question. Chances are, if you're asking it, so many other people also want to get the answer. So go ahead and put those questions in the comments. I'm here to answer. On YouTube, Facebook, I am here, and go ahead, ask your questions. Okay, so is there any pardon for working here in the US? So usually, now keep in mind that if you are in the United States, you're going through adjustment of status through a spouse, you're going through VAWA, you're going through the T visa, and you're going through the adjustment of status through a U.S. citizen spouse. Working without a permit is forgiven. Working without a permit here does not affect getting permanent residence once you are going to consular processing. It doesn't lead to a lifetime bar. It does lead to a bar against adjusting status if you don't fall within those exceptions, right? So I just listed marriage based to a US citizen. If you have the parent, you're under 21 and unmarried, if you're being sponsored by a child, if you're applying for VAWA, if you're applying for the T or the UTs for victims of trafficking or um, victims of crime, and also asylum, they do not hold that against you. However, you really do have to just leave the United States. So it does bar you from visas, it bars you from adjusting status, but it does not necessarily bar you from getting permanent residence. But the visas, it does. If you have been working without a permit and you're already outside of the United States, it really is up to the officer at that point to determine whether they are going to forgive the violation, and they would usually look at your record to determine whether you qualify for a waiver there. Can I apply for a student visa or one of the work and travel visas, even though my visitor visa got canceled? So unfortunately, those do require for you to be temporary, meaning that it's the same as a visitor's visa. So if you do have any violations or they canceled it because of an overstay, the student, it's going to be still bad for your student visa or your B1, B2, or any other temporary visa. All right, I see a question here on YouTube. Oh, two questions. So I, hi there, good afternoon. Any possibility after marriage fraud accusations, please? May be. Now, once you do have marriage fraud accusations, keep in mind that if you've been accused of marriage fraud, you need to fight it, right? Do not take it lying down because you are going to regret it. If that is marriage fraud is set in stone, like in a conviction, or if you do not respond to the accusations of marriage fraud, you are permanently barred from getting the green card. So if you're in a marriage-based application and you know that you have not committed marriage fraud, sometimes some situations can be construed that way. But if you know that this is a misunderstanding, there may be the possibility. If you know it's true, you don't have a case, right? And this is why I say never, ever, ever put yourself in that position, right? It may seem enticing, but it is not. Um, I was once speaking to someone who was so desperate. They were in a relationship with a spouse that was abusive, and clearly they qualified for VAWA. But then at the same time, the whole concept of maybe just remarrying someone else and getting it in a quick business thing seemed more enticing, and it is not. Trust me, it is a nightmare. You don't want to get there. You don't want to marry somebody and get into a situation like that because it's very, very hard to get out of it. You'll find yourself deported in court, getting deported, and never being able to get relief. So keep that in mind. My mom is visiting the USA and I'm a citizen. Can I file for her green card? I already did the I-130 states that she's here. So, yeah, it may be a possibility. Your mom cannot fly into the country though to apply for adjustment of status. That is considered an immigrant intent at the time that you're presenting to the officer that you don't have immigrant intent. And when that happens at the airport, they can then turn around and charge you with fraud or misrepresentation. So you want to remember that. Usually, where I see adjustment of status in a case like this is where the parent is already here, and then they decide, you know what, let's go ahead and do the adjustment of status and move forward. If you're a citizen who's age 21 and over, your mom is already here, then adjustment of status could be on the table. Another thing to keep in mind, though, is here's a disclaimer. I'm not your attorney. I don't know what your situation is, and I don't know what your mom's situation is. So you should not be running and filing for adjustment of status unless you actually do an appointment with an immigration attorney. I can definitely speak with you in a private consultation, determine whether she definitely qualifies, and move forward from there. Um, All right, let's see. I see. So I see another one. So my country revoked my passport. Is it possible for me to apply for citizenship? I'm a green card holder. So this one, you have to be careful as well, right? Because if you go ahead, if your country revoked your passport, we need to understand why. Because that answer could then lead to more issues in regards to getting citizenship. Does it raise does it put doubt on your good moral character? For example, revocation of your passport in the US could mean that there's a failure to support children. And so, failure to support your dependents while you're applying for citizenship is a ground to find that you don't have good moral character. And if that's the case, you will be denied citizenship. So it's not as simple as they revoke my passport. Now, can I just go for citizenship? It's really, we have to dig down into those layers to find out why would your country do that? What's behind that? And then does that, whatever that reason is that they revoke the passport, stop you from getting qualifying for citizenship? Okay, so the consultation fee is $150 for up to an hour. And I really just go into your details to make sure everything is good. And then we get started right after that, as long as you qualify for my representation. All right. Great questions so far. All right, I think that's going to be it today. Thanks so much, everyone. You're welcome, Kenny. Thanks, everyone, for your questions. These were great questions. I will be back on Monday. Yeah, so I think, Andu, go ahead and schedule an appointment and let's talk about it in private. And we can do a full evaluation and determine how to move forward. Denroy, you're welcome. Thank you for your questions. I enjoyed our live today because I got to hear your questions. I will be back on Monday. So have a great weekend and start thinking of more questions that you want to ask so I can address them on Monday at around noon on Monday. And I will think of a great topic. I'm thinking on Monday, I'm going to talk about asylum. Asylum, especially in regards to you coming through the border. So those who are coming through the border, what are their options in regards to asylum? There is a deadline to apply for asylum that you should know about, even after you've crossed through the border. And then I want to also talk about asylum if you come into the US and you are afraid to return home. What are your options in regards to asylum? So I'll be excited to explain that whole process to you. So have a great one. And let's see. So I see somebody here said, so Anika, I don't see those questions. I don't see any of your questions, but I have to go. So you can definitely ask those questions on Monday. Have a good one. Bye-bye.